She has significant experience in representing debtors, creditors, and equity holders in bankruptcy matters, both in contested bankruptcy proceedings and other matters. She's admitted in all courts in Texas and Louisiana, and we're excited that she's here with us tonight.
Thank you for inviting me. And this is, I think, one of the most unique bar associations out there. I know a lot of us are just doing pure Zoom meetings. So kudos to you guys for trying to do the in-person social distancing, mask wearing meetings as well as the Zoom. So I am very pleased to be here. Does anybody think it's timely to talk about bankruptcy right now? Yes. Kind of an understatement. We are still seeing low numbers because of the financial assistance that's been given as part of the CARES Act that is expected to change as forbearances and other concessions start going by the wayside. I'm seeing just as of this week, a lot of uptick in calls, especially on the business side. So that's going to start happening. Now, the question is, will it be a tidal wave, a tsunami, or more of a steady flow of issues? If you're in the business realm, those are all predictions that are still left to be had. I would suggest it's not going to be the tidal wave people thought or the tsunami people thought. Certain lenders are certainly being more aggressive than others. Some lenders have decided to hold off to the new year. Others are starting right now. Your independent lenders are going to start sooner. So on your smaller business cases, you're going to see a lot of that happening sooner. On the consumer side, a lot of people are paying off their debt. They're paying off their credit cards. They're using some of the extra. Some are making more money with some of the CARES Act relief than they did when they were working. So once unemployment benefits cease, we'll see how that pans out as well. I primarily do business bankruptcy, not consumer. I have done all. I've represented Chapter 7 trustees. I've done creditor work in 7s, 13s, and 11s. But some of my presentation today will be more business focused. And if you have questions on the consumer side, I'm not sure for those that are attending by Zoom, I'm not manning a computer to do a chat. But if
We have a chat window.
you do have a chat window open. So if there's questions that come up, I can answer those through the program. And I'm happy to have you interact. I work best with people asking questions and giving responses. So what I'll do is go ahead and begin. I can see the arrow down there. There we go. So how many people have done bankruptcy before? Okay. We have a couple here who've done some bankruptcy, consumer mainly. Okay. So this is a pretty generic description of the different types of bankruptcy. Chapter 7 is a liquidation for both businesses and consumers. So individuals and businesses can take advantage of Chapter 7. Pure liquidation, a Chapter 7 trustee gets appointed. The Chapter 7 trustee takes control of all the assets, and that means everything. So if you had pending litigation that you're representing the debtor in pre-petition, or you were doing something else for the debtor pre-petition that relates to his assets, trustee controls that, not the debtor. If you were owed money pre-petition, the trustee controls now and is through the claim process. The next item is Chapter 11 reorganization, and that's used by businesses and individuals. A lot of people think of Chapter 11 as just a business chapter of the bankruptcy code, but individuals who are not high net worth will file Chapter 11. Does anybody know what the benefit to Chapter 11 over 7 would be for an individual? Control of the assets, control of the case. You don't have a trustee who comes in and takes control of everything. So one of the reasons Chapter 11 can be desirable is to be able to control and how you're going to proceed going forward. You file a plan and a disclosure statement. That plan then dictates how the creditors will be paid. Creditors don't have to be paid, they have to be paid in the priority scheme of the bankruptcy, which we'll talk about later. They don't have to be paid 100%. They can be paid a percentage of what they're owed, the unsecured creditors. Secured creditors obviously get paid what they're owed. A lot of times you can work deals with secured creditors and carve out, so bankruptcy is all about deal making. And so you don't go in there thinking you're going to be foreclosed or it doesn't make sense, because there's usually some type of opportunity that can be done. It's all about the deal. Because it's expensive to do a Chapter 11. So chapter 11 is a much more expensive option. Your retainer on a chapter 11 is going to be higher. Clients going to want to put aside extra money. If you're working with clients that are contemplating, they're going to need that retainer for their counsel. If they many times will stop paying their mortgages or stop paying some of their trade debt so that they can afford the retainer for counsel. And again, once the bankruptcy is filed, they get that automatic stay, and so they'll have some of that freedom to try to, use their cash flow and gain up some more ability to pay creditors on a go-forward basis. Chapter 11, Small Business Reorganization Act. This is a new part of the code, brand new part of the code, which just got modified by the CARES Act. So has anybody heard of SABRA, SPRA? This was thought to be the new age of bankruptcy for small businesses. Any business that had 2,700,000 approximately, or more in debt could file a small business case. That would give them an opportunity to have a more streamlined process without all the rules and regulations that apply to the big chapter 11. They also appoint a trustee who will oversee the compliance with the code, but does not take control of the asset. So the debtor still keeps control under SABRA, and it's supposed to be more inexpensive. You're going to get counsel that will have a lower rate. The trustees have a pre-negotiated rate with the U.S. Trustee's Office, and those are generally between $350 and $450, depending on the trustee. There's a group that's been pre-selected. They're all very easy to work with. The primary role in the case is to try to mediate a deal between all creditors to get a consensual plan, so you still get a plan. The other benefit is nobody else in a SABRA Chapter 11 can file a plan. In the big Chapter 11, creditors can file competing plans against you if you don't plan and confirm one timely. You have 120 days of exclusivity, which you can extend, and 180 days if you file your plan timely. In Chapter 11, you have 90 days, which arguably, there's a lot of law to be made yet in SABRA, but you have 90 days and you're the only party that can file the plan. So you would go in there with an idea of what your go-forward plan is and how you plan to get out before you file. Chapter 12, we only see a handful of Chapter 12 cases down here in the Southern District, but it's for farmers and fishermen. You see a lot more of them up in the Lubbock area and in the Northern District. Chapter 13, you'll see a lot of with consumers. That's basically your Chapter 11 for consumers. You pay out your claims over time. It's usually a 5-year plan. It doesn't have to be 5 years. It can be less than 5 years. The big issue that everybody should consider here, whether it's in Chapter 11 or Chapter 13, when those plans are confirmed, those are contracts between the parties. So if you have some other agreement that gets modified by the plan, that is your new contract with the party. And it would be a violation of the injunctions in those plans if you try to pursue the prior plan or the prior contract with the party. Go on to the next slide. Who has had anybody claim the automatic stays invoked? You don't have any rights to keep going. That's one of the primary reasons for filing bankruptcy, to get the automatic stay. So on the eve of foreclosure, they run and they file a 2-page petition to initiate bankruptcy. They haven't done any of the work to do the schedules and the SOFA, but they know they have electronic ability to file their petition whenever. It can even be at 9:50 before a 10 a.m. Auction, which happens all the time. Not unusual. I can't tell you how many times we've been contacted by somebody who wants to file that day. And you have to take those cases with a lot of caution because they're usually the high risk cases, especially on the consumer side. I just did one where I was the creditor. They filed the day before auction, probably 9 p.m. before auction. They didn't provide notice to us. I had to look it up to see if they had filed the emergency motion to have the stay being lifted the next day. So before noon the next day, the emergency motion was filed to lift the stay. The hearing was held in 3 to 4 days. Case dismissed because the debtor knew it wasn't going to be pretty going forward. So there are ways to combat debtors who do that to you if you're on the creditor side. And there's definitely a lot of value to the debtor to file because of the automatic stay. Automatic stay bars just about everything, but not everything. And so that is something to be very conscious of. Not everything is barred, but don't be making new law. Like if you're not a bankruptcy lawyer and you haven't like consulted one, but you did some research and looked at some white papers and, oh wait, I don't think this is covered, be careful. The judges aren't real tolerant if you come into bankruptcy court and start spewing new theories that there's no cases that support, because rest assured, if it could be done, it has been done. Everything's been tried. We've got, creative lawyers in bankruptcy that try everything, and if it doesn't work, you're not going to be the one that proves it up, Now that being said, maybe there is, maybe there's some new code provisions out there that change. And so this is where I've given you where the automatic stay exception applies. The most important one, liens. So if anybody has mineral rights, mechanics liens, there's an exception for filing your lien under 546 and 362(b)(3 of the bankruptcy code. That is not a violation of the stay to go ahead and perfect your lien. In fact, you're going to want to perfect your lien because otherwise you might be SOL on collection if you had some type of security interest that you didn't perfect timely. And obviously under the M&M statutes and the mineral lien statute, you have to keep 10-day notice. You have to be very careful in your 10-day notice letter not to make demand for payment, especially on mineral liens. There's nothing in the code that allow for, you're not making demand for payment. There may be fund tracking positions, but you're just trying to perfect your lien. You're not taking any active motion. You're just perfecting your lien. Another important part of the automatic stay, does anybody know to the extent that it covers co-debtors? You think the automatic stay is going to cover an action against a guarantor, for example? Got some shaking heads, no. It could, though. Depends. It's another one of those depends. Sometimes, especially in Chapter 13, there is a co-debtor stay. So it's another one to actually look at, but why take the risk? We file motions for quote comfort orders in bankruptcy court a lot. That's just if it's on the fence as to whether or not the stay applies or not. Better to be cautious than pave your own way. That way you're definitely covered. Why would I suggest being cautious about violating the automatic stay? Does anybody know? Sanctions. The first thing debtors counsel is going to do is go ahead. I've got a motion for sanctions. We violated the stay, and those get granted. Because if you had an intentional, it doesn't have to be with intent to violate the stay, but if you did an intentional act that violates the stay, you could be subject to sanctions. So they have to reach out and try to work it out and all that. So the other part of the stay that could apply is to directors and officers, depending on the language involved. So there's a lot of nuances there where the co-debtor stay, not the co-debtor stay, the automatic stay can sometimes apply. It's rare, but sometimes it can apply. The other benefit when a debtor files bankruptcy to the co-debtors is you can remove litigation where you might be a co-defendant because you have 30 days to remove from the time the petition is filed or 90 days from the time the bankruptcy is filed. So even if the case has been pending, you can go ahead and remove that after the debtor files. Even if the debtor doesn't, if the debtor like, it doesn't really affect me. But if the debtor is like a party that's a necessary party and a judgment against the debtor will negatively impact your client, and the bankruptcy court has related features. Bankruptcy courts move fast. Bankruptcy courts have sophisticated judges. There's a whole heck of a lot less politics, in my opinion, in bankruptcy court than in state court. And those would be some of the advantages to removal. Yeah.
Say remove to the bankruptcy court, not the federal district court.
Well, by statute, it's to the district court and then to the bankruptcy court, but there's an automatic order of referral in the Southern District. So if you remove from state court, it goes directly to bankruptcy court. If you're in Bear County, you have to remove to district court and you transfer to the bankruptcy court. Has anybody helped a client with a proof of claim? No. Okay, here we have one. So proof of claims are very important, especially in consumer cases or in chapter 7 case. So in a 13 or a 7, you must file a proof of claim. Otherwise, you no longer have any rights to what's owed. If you're in chapter 11 and you have your claim properly listed under schedule, and I'm going to step back. Does anybody have a basic understanding of bankruptcy and schedules and so forth? So most do, but I'll give an overview. When a debtor files, they file a petition, they file schedules, which list out all of the assets, all the liabilities, all the equity interest holders, any litigation, that's all in the schedule. Secured creditors, unsecured, priority creditors. And then in the statement of financial affairs, they answer a series of questions of what's happened usually in the last 2 years, what it covers. And that would be payments made in the last 90 days, payments in the last year. So all of that information is filed once the debtor files bankruptcy. And a litigation tip, if you're litigating with anybody who's filed bankruptcy in the past, pull those records and see if what they're telling you today is consistent with what they said before. Sometimes, if it's a claim that predates their first bankruptcy, they're actually a stop from even continuing to pursue it because it was never listed in the original bankruptcy. And I've gotten clients out of multiple lawsuits that way because they didn't think he filed the bankruptcy, and the trustee would have had authority over the case in chapter 7, and if it wasn't listed, they're a stop from going forward. Usually that's just a call to the other counsel, like, oh yeah, okay, so that would be another sanctionable.
Earlier, you, on chapter 7, you said the trustee takes over all assets of the filing entity. So if there's ongoing litigation where either as a plaintiff or defendant, do the lawyers still continue to work the case? Do they have to report to the trustee or what?
So I have that later. So the lawyers the lawyers aren't going to continue in the case as lawyers for the debtor's estate unless they get employed by the trustee. So if they think it's a good case, they're going to pitch to the trustee that they should be retained. Usually the trustee will retain the pre-petition counsel, but it's up to the trustee on who will take that case going forward, and then the trustee is substituted as the proper party for the debtor.
If the party that files to be on the defense side and there's insurance coverage, is that insurance coverage part of the estate?
So yes, and one of the ways that you can resolve those issues, a lot of times the trustee doesn't want to allow you to come against the estate, but doesn't really care if you go against the insurer, right? And so a lot of times you can enter into a stipulated agreement with the trustee that you're able to pursue, but only to the extent that you're seeking insurance proceeds. And you can do it as a stipulated agreement. Okay, so what we have here is with the proof of claims in 7 and 13, you have to file. In 11, you don't have to file proof of claim if your claim is properly specified, but if it's not, you do. And most of the time, you're going to want to have some protected language. And most of the time, the numbers aren't going to match exactly. But does anybody know why you might not want to file a proof of claim? Because you might waive a jury trial. If you think there's going to be some type of claims against you later, then you might not want to waive the jury trial. It's not an absolute again, because nothing's absolute, but more often than not, you waive a jury trial and file a proof of claim, so the proof of claim becomes, you've accepted the jurisdiction of the bankruptcy court by filing proof of claim. The proof of claim serves as a complaint. It actually has the same effect as a complaint, so when somebody objects to the claim, that's basically the proof of claim, and that's how the burdens work. And I've cited to some of the cases here on the report, cases that reference that. Again, it's not absolute. There is an ability in bankruptcy court to do jury trials. It's rare. I think Judge Isker has done 1 or 2, but usually what you'll do is withdraw the reference to the district court. The district court will then oversee any jury trial, and the bankruptcy court many times do all the pre-trial, and then make a report and recommendation to the district court, just like a magistrate would do. All right. So here's another tip. Now, some of your clients might end up being employees of big companies that file bankruptcy and have claims for wages or other things. Or you might have just some of your, suppliers in the area that have claims in the big bankruptcy. They're kind of intimidating because there'll be thousands of records in, whether it's in Delaware or now the Southern District, because we're one of the big places to file the big cases now. But many times you can get the documents for free in the big cases online through the claims agent's website. And if you go to the claim, you can just search the name of the company and claims agent. You'll usually find which claims agent they're using and the docket of the case, as well as a sample draft form of the claim and the most relevant deadline. You have to double check everything. It's usually on the claims agent's website. You can also usually, depending on the order that was entered on how to file proof of claim, you can usually file your proof of claim in the claims agent's website as well, versus ECF. It's to make it easier for creditors that don't have counsel, so that they can file it. You can now file as a non-attorney on ECF as well, but it's a much easier process on the claims agent website. They prepare the form for parties as well, and there's electronic signatures. In the Southern District, we now have an order where electronic signatures are allowed. So even on a debtor's petition, at least during this period of time, electronic signatures are allowed. During the COVID period, it's part of the emergency order. Is insolvency a requirement for bankruptcy? Lots of people think it is. It's not. Solvent companies file bankruptcy all the time. It's a way to reorganize, restructure, and keep ongoing operations. The purpose is actually to file before you become insolvent so you can preserve the company. That's part of the purpose of the bankruptcy. So that's one of the misconceptions you hear a lot from non-bankruptcy attorneys. Venue. Lots of discussion in the bankruptcy realm about venue and whether there should be venue reform. In the Southern District of Texas, there is a recent complex case order that was issued several years ago now. It's been several years. And it's kind of made the Southern District a hot spot for filing because you'll get one of two judges, Judge Jones or Judge District. Before, there was at least one judge that people had concerns with. You didn't want to take the risk of the roulette wheel, landing on him. And so now what you have are two very sophisticated, pragmatic judges who value the big cases being filed here, who are very efficient in how they handle it. And they will sit there and draft the orders online while you're there. Or they'll edit the orders and edit the things for you while you're sitting there. So, and they know how all of the electronics work. So when COVID hit, they didn't miss a beat. They already had procedures in place. So that's why Southern District has become a pretty big venue for filing. But you can see with the venue definition, it can be stretched. I'll give you one example of a debtor who opened a bank account in Houston. Therefore, they had assets in Houston. And therefore, they get to file in Houston. And it was a foreign company, like out of the U.S. company, So there's been creative strategies. You can always file motions to transfer venue. If somebody doesn't want it here, they can always try to transfer it out. And there could be big fights over venue transfers. And like the subsidiaries can all file here too. So if they don't have assets, so like when J.C. Penney filed, it had 40 companies. Well, some may have ties to Houston, but they don't all have to have ties. Just one. You just need one debtor to have a tie to Houston and the rest of the file. All the affiliates. So this was the related to jurisdiction I touched on a little bit before. The bankruptcy court has core jurisdiction over bankruptcy, right? Like anything relating directly to the debtor's petition and assets, the bankruptcy court has jurisdiction over. But it also has related to jurisdiction, and how far related to goes becomes an issue that gets litigated quite a bit, because people do try to remove cases or transfer cases or file cases in the bankruptcy court because it's considered a better venue than in state court. Or maybe you have 5 different pieces of litigation all over where people were trying creative strategies pre-petition and litigating against the party by raising the same claims in different venues. But once you file bankruptcy, you can remove them all, consolidate them all, and try to deal with them at one venue. Many times, if it doesn't involve the debtor's assets, you can have a remand action, and they can try to remand it. But it can be a very cost-effective way of dealing with litigation for all parties involved. Because many times litigation is draining on everybody, draining the resources, and that's where bankruptcy can help. Has anybody heard of ipso facto clauses? Does anybody draft contracts for anybody? No, we have transactional lawyers or anybody who's drafting contracts puts in a provision that says upon bankruptcy, it will be deemed a default, right? Completely worthless once you hit bankruptcy. It's still important to put in there because everybody doesn't know it's worthless, and they try to comply with it as best they can because they think they'll be in breach. But those aren't enforced in bankruptcy, especially in leases, et cetera. So one of the positive or negatives if you're the landlord to bankruptcy is there's a cap on how much damages a landlord gets under a lease. So if a small business has a 10-year lease, guarantor. But if it's a lease without a guarantee, you can really minimize the obligations. And it can be used as a negotiating tactic with the landlord to be able to try to get some forbearances or to get some extensions for taxings on the end so that you don't have to file if the landlord understands that. A lot of your landlords, if you don't have multiple properties or aren't big landlords, can be more aggressive than the big guys because the big guys understand the process. So a lot of it can be an education for the landlord. And there's all kinds of default clauses that get put into contracts. Again, there are exceptions, but they're rare to have exceptions. And this is touching on the questions that were asked earlier. If the debtor has counsel, they have to be approved by the court in any Chapter 11 action. In Chapter 7, the trustee gets all of his counsel approved by the court. And then lawyers then have to submit fee applications in order to get paid. Even on usually a contingency case, so let's say you're doing a personal injury case pre-petition, you're going to have to make sure you get employed by the court, that you have authority to pursue the action, authority to settle the action, and that comes up the most with non-bankruptcy lawyers. So go ahead, be representing the debtor. Sometimes they actually get employed, and they settle it, right? Because that's usually just negotiating goes back and forth. Once they settle it, they fail to do what's called the 9019 motion in the bankruptcy, which is a settlement motion. And that settlement can be void. And it can run a lot of problems. There was at least one attorney who has been disbarred because of problems that arose from, she complicated the issue further, but problems that arose from settling a case without having court authority or being employed. No, actually, she was employed, but without having court authority for the settlement. So you've got to be very careful when you get involved in bankruptcy, consult with your bankruptcy friends. You can do it. It's just, you need to make sure you follow the procedure. Do you think you'd have to get mediation approved? That's new case law. In the past, you didn't, but now you have to get mediation approved. Hiring experts, gray area. So some courts are going to say the expert has to be approved, and some aren't. So that's all things to think about when you take on those cases. The trustee can help you, or your bankruptcy friend. But you must be employed. You must have everything approved. When in doubt, it's best to stop and ask the court for permission. If you're not there all the time. So has anybody had to review disclosure statements and plans in any Chapter 11 cases? We have one again. So the disclosure statement, just to kind of break that down for you, it's usually a pretty lengthy document, 30 to more pages in big cases. But even in your smallest cases, you'll see 15 to 30 pages of information about the debt. The purpose of a disclosure statement is to disclose the history, what brought the debtor to bankruptcy, and how they're getting out of bankruptcy and how they're treating their creditors and claims. A lot of times stuff gets buried in those, so you review them closely. The disclosure statement, sometimes people object. They say, oh, it doesn't have enough information. Unless it's grossly erroneous, the courts just are trying to make sure you have a general gist of what's out there, and they're not going to care. You can work with the other party to have the language you want added. So when in doubt, call the debtor's counsel and say, this is language I want added versus object. Because that way you'll probably get the language in there without much issue. If the debtor, hems and haws or doesn't agree to it, you can file the objection. But the courts don't look favorably on those types. It's kind of like a waste of effort in the bankruptcy court for the most part. Just the judge playing parent and telling you to do what you do, usually. The plan of reorganization is very important. So you have to have the disclosure statement approved before you can notice out the plan, and then the parties vote on the plan. And after the plan has been noticed out, the debtor can solicit votes, but before, the debtor can't. You can't enter into any type of collusive deal with the debtor. You can't say, oh, I'll do this for you or that for you. Those would all be Title 18 violations, criminal violations under the bankruptcy code. But once the plan is actually noticed out, the debtor will reach out and say, are you going to file a proof of claim? Because a lot of times they'll need your proof of claim, not your proof of claim, your ballot, your voting ballot. A lot of times they'll need your ballot to make sure that they have the required percentage past that class. Each class of the plan votes, and the debtor has to make sure it has 60% total in order to get that class approved. All classes don't have to approve of a plan, but they need to have one impaired class approving the plan. Usually it's the unsecured, but sometimes it can be other classes in the plan. The other things that are important in the plan is to look at the releases. If you think there are claims against director and officers, many times there's going to be blanket language in the plan that releases those claims. And if you let that go forward and not preserve those claims, the contract governs. The plan becomes an approved contract between the parties. And it doesn't matter what you put in that proof of claim or how much backup support you put in the proof of claim. You could attach your litigation to the proof of claim, the complaint to the proof of claim. If you allow a plan to go forward that has language that dismisses that case or basically wipes out those claims, the plan's going to govern. So you have to not only monitor the proof of claim process, but also the plan process.
We have a question on chat.
Yes.
I'm not sure I follow up, but maybe you can. It says, no disclosure is required for SBRA, correct? Other than as may be referenced in the plan itself.
Correct. And when I refer to chapter 11, I'm referring to the general chapter 11. Sabra also has a lot of other differences, which I don't know if we'll have time to go into, but there's certain things that aren't required under Sabra that are going to be required under chapter 11 that make Sabra what they think an easier process. You still have to file, in some ways it can be harder for clients because they don't have the financial reporting required when you first file, because a lot of your small business clients don't have accountants on hand, they don't have quarterly financials, they don't have, many times they don't have their tax returns done timely. So the other thing is the exemption. And so, especially for individuals, under Texas law, it's a debtor-friendly state, right? We all know that. Like, we all know that just generally speaking. So your homestead in Texas, is that exempt? Is it always exempt? No, because nothing's ever always, right? So if you have not owned your home for more than 40 months, then it's not exempt in its entirety. So you're going to be capped on that. So you have to have owned it more than 40 months before filing. So today, or yesterday, I had a call from a guy who's owned his house for 3 years, 36 months, right? Are you sure you want to file now, or do you want to wait 4 months? Is there anything pressing that's making you want to file now, other than you'd like to be a planner? So those are things you have to think of up front. Most people will tell you homestead is exempt. If you commit fraud or used funds defalcated from other sources to purchase the house, you can be subject to an objection to your exemption. And I've won several of those. So you do, and you see more people winning on objections to homestead than you used to. So that's something to also be cautious of. Texas is certainly a property rights state, so it's hard to bust an exemption on homestead, but it's a risk. You want to make sure before you allow your client to file, or you advise your client to talk to bankruptcy counsel to file, that they look at the big picture. Because a lot of times debtors file bankruptcy that never should have been in bankruptcy. If there's anything hinking in their background, they should not be filing bankruptcy. Because this is the one thing about bankruptcy everybody should know. It is a spotlight. One judge actually described it as, it's as if you're standing in front of him in your underwear and all creditors, in front of him and all creditors in your underwear, and they get to scratch and poke you until they're done. Because that's how it is. Full disclosure. There's another case that says disclose, disclose, disclose. So even if it's not good, disclose. You know, it's ask for redemption type of policy, right? Be honest and ask for redemption is what's another judge's quote. Yes.
This is more of like a practice question, but how do you approach clients that don't want to necessarily give you full disclosure on the front end? I imagine that's a big client counseling issue.
It is. I actually somewhat known for my research. So the attorney has a due diligence requirement. And so you pull the credit report, so you'll have all that information. You should do a PACER search to see if they pop up in any prior bankruptcy. You do a state court search to see if they pop up in any bankruptcies or other litigation. A state court search. I usually also do a Lexis report. I'll do independent online searches. I'll look to see if they have open social media to see if they're misleading me. So I do a lot of that front end, and then I ask them about things that they haven't told me about. And there's always that risk. And if somebody's giving you a concern that they're not giving you full information, you may just not want to take it. You can get to the point where you're like, I'm not feeling comfortable that you're giving me full and accurate information. Because a lot of those clients are the ones that then turn on you and say, oh no, I told them this, X, Y, and Z. You document everything. Even if you had in-person meetings, you document that you had an in-person meeting. You keep the originals of anything that they've signed. There's a wet sign rule in Southern District. We have to maintain those records for 5 years, the originals that are signed. And that becomes very important. Right now, there's an allowance for electronic signatures, but many times bankruptcy cases will turn on whether or not the debtor actually signed the deed. Even if they gave you all the information, if they couldn't come in and they say, oh, it's okay for the paralegal to sign, and the paralegal signs their name, and you don't have the original copy with their signature, there's going to be a brouhaha. And there have been many brouhahas over those types of issues. And then it becomes the attorneys against the client. New attorneys come in, maybe 2 or 3. So it is a real practice issue, and a lot of it has to do with your gut. I have turned people away who I don't think are being full and accurate, or who want to take positions that I don't think will actually get to a result. Whether they're right or wrong, if I don't feel comfortable that we're going to be able to reorganize the company based on what they want to do, and they're insisting that I just take orders, then I'm not going to take it. And I've given up some big cases like that. But at the end of the day, the company failed. And so we're in the business, I guess we're in the business of making money, but unfortunately that's more secondary to me than actually helping the company, right? So to me, the goal should be helping the company and how you can get it resolved and not just taking orders from them. Those are usually the ones that aren't telling me everything. Okay, so are there any other questions? Well, I didn't go over these. I don't know how to get back to it. So the homestead is obviously the key exemption, but there's also a difference between your federal and your state exemption. And the federal exemptions are not very favorable to most Texas debtors. And so you'll almost always file under the state exemption. So you get to elect in Texas whether you're in Texas or federal. which is different than, and keep in mind, this is for Texas. You know, I practiced originally in Louisiana, and the exemptions in Louisiana were not good, and we always use the federal. Because your homestead is an exemption, there's all kinds of other things in Louisiana where the federal were more desirable. Back in the day, they may have changed. I haven't been practicing bankruptcy in Louisiana. Consumer bankruptcy. So this was just some, there's other exemptions, but one of the big things to think about is your IRA. Your IRA is going to be exempt under Texas and federal law, but it's capped under federal law. There's no cap under Texas law. But there's a nuance to the IRA exemptions. So let's say you had some extra cash in your account, and cash isn't exempt. So you're like, oh, I'll just put 80,000 in my IRA. It was exempt. Now, too good to be true rule, right? Because you're limited to, under the IRS regulations, on how much you can put into the IRA tax exempt each year. And that's going to be your limit under case law. That's going to be found appropriate. So I've had some cases where we actually go through, you know, the Morgan Stanley reports month by month, to see how much money was being put in, and to see if it exceeded statutory tax. So that's one thing to keep in mind. You can't just shield your assets after the fact. If you have a beneficiary interest in a trust, because a lot of people set up trusts to protect their assets, those get disclosed as assets. And some are exempt, some aren't.
Some, the trust are exempted or some.
Your beneficiary interest.
Okay.
So a lot of times the person shielding the asset does not become a beneficiary, right? They put their assets in the trust, but sometimes there's these trusts that are set up by the grantor, and they also name themselves as a beneficiary. And then file bankruptcy. That can run a risk. So spendthrift trusts usually have an exemption that applies. There's a lot of case law and statutory issues that you have to consider when there's trusts involved. So trusts aren't an absolute protection if you've got a sophisticated creditor on the other side. Many times it will pass through, but whenever you have sophisticated creditors or the U.S. Trustee's office, they'll question you as well. Because in the beginning of a case, you have what's called the 341 meeting of creditors. And at that meeting, which usually lasts 5 to 10 minutes, anybody can show up and ask a question. Ask the debtor. The debtor is basically under oath. It's a free deposition. And the trustee can let him go as long as the trustee lets him go. You can object if you're the debtor's lawyer, but the trustee can let him go for 15, 20 minutes if they think they're going to bring out some real information that's going to help. And you see that over and over. When people know it's a more informal setting, you just sit at a table with a reporter, no different than what I'm doing right now, and you're asked questions so people are a little bit more free with their answers, and they don't prepare. The debtors have to be prepared before they file as what they're asking for. They can't just rush through pleadings, etc. Especially if they have anything that raises a red flag. They need to be prepared. That's the biggest thing I can tell you. Whether it's a Chapter 7 credit debtor, Chapter 11 debtor, Chapter 11 sovereign debtor, they have to be prepared. They need to know what to do. You should give them videos on how to testify. Most of the time, a debtor, even if it's just like somebody in your family or friend, most of the time a debtor, that's the first time they've been to court. They've never been to court before. It's scary. They've never been asked questions with somebody, like prosecuting. They have to be prepared, just as if you were preparing for a deposition. And so I will send them videos. I'll tell them to review the documents. I'll send them to them again. I'll spoon feed the information so that they have it readily accessible. So there's less excuses on why they weren't prepared. Because, you don't want your client going down early on in the case, and that 341 can set the rest of the case. It can turn the case positive or negative real quick if the debtor seems less straightforward. That's probably one of the best tips right there, is where a lot of cases go off the rails is at that 341 meeting, because the debtor is kind of taken by ambush. They don't know what to expect. They haven't been prepped properly, so they really need to be prepared. And I'm getting close towards the end. So is there any questions or time for questions?
This
We've got-
Okay. So if there's any questions, I'm happy to answer.
Early on, you were saying that trustees could be of benefit to counsel representing the debtors. Back in the day, it was really hard to get in contact with trustees. They were, maybe it's because they were so swamped with all the cases being filed at that point, but you might call, because all you could do is call, no phone, or no email, nothing like that. And you never knew where they stood, what they wanted you to do. So you showed up and then they go, oh, and you're left holding back.
Yeah, so there's 3 different trustees, right? We have the chapter 7 trustee, 13, and chapter 11. The chapter 13 trustee has the highest volume, and they have a team or a staff, and you don't usually contact the trustee himself or her. Right now in Southern District is they're both gentlemen, but you can talk with their staff, and they have people assigned. You go to their website. They're very efficient, frankly, and I would be surprised if you wouldn't get a response by email. And email is probably best. But there's, the chapter 13 panel gets called, people know what the process is, and so if it is your first time, it'll be foreign to you. Reach out to another chapter 13 attorney, you can reach out to the staff, they've always been very helpful. I enter that venue every once in a while, but it is definitely much more of a process for to keep people moving. And the trustee's attorney, the chapter 13 trustee attorney will sit there going over each case. So if you have any issues where you need to pass a hearing or you need to talk with the trustee, that is an opportunity at some of those initial hearings to just reach out to the trustee's attorney. Chapter 7, they have a lighter caseload than they used to back in the day. That may go up shortly, but the chapter 7 trustees are usually, in my experience, been pretty easy to reach out to as well. At the 341, you have to provide the driver's license, the tax returns. And you'll get a list of those items ahead of time from most trustees, unless required. And a chapter 11 trustee, a trustee can be appointed. I mean, you can also have what's called a CRO or an examiner. So a debtor may have bad actors who are their office directors or management. And the debtor's counsel may be, I don't think we can file with them. That's just going to create all kinds of problems. Secured creditor is never going to support that because they believe these guys are the bad guys. So you put in a impartial third party to manage the company. And it happens all the time. And it's cheaper than a chapter 11 trustee. So instead of waiting to the bankruptcy is filed and then fighting over whether to appoint a trustee, you can work that out ahead of time and be a little bit more economic. So I think that's been cured. But when you do have issues, you can always go to the U.S. trustee's office. And the U.S. trustee's office will definitely take note of that. Any other questions about the bankruptcy process? All right, thank you all for being here. I really appreciated it. Hope I provided some helpful information. I know it was a big topic, so I hope we focused it enough on issues that help you all.
Thank you so much.
Thank you.
Awesome. Okay. Trying to remember who next month is. Next month is law office technology, and it's going to be a lunch next month. Yeah. I think we're going to do the same, keep doing the hybrid, some Zoom and some in person. So just remember to register ahead of time if you're happy. Rocky Pilgrim. We're excited to have her. Yeah,